Hello, everyone, and welcome to the first webinar in our second annual commercial litigation series, The Contract Speaks for Itself. Or does it? How to address mistakes, rectification, and ambiguity in contracts. Thank you for joining us today. While I introduce myself and our speakers, please see the information slide that is on your screen. I'd like to draw your attention to the survey at the end. We truly value feedback on the sessions and encourage you to fill out the survey before you log off of the webinar today. My name is Jennifer McAleer, and I'm a partner in Fasken's Toronto office. I have a broad practice with a focus on commercial litigation. And today I am joined by colleagues from across the country. Kotkas is a partner in Fasken's Calgary office. He's a senior litigator at Fasken and is the founder of the firm's litigation and arbitration group in Calgary. Kaleigh Milinazzo is an associate in our Vancouver office. Her practice focuses on commercial disputes, white-collar crime, and regulatory defense matters. Nicolas-Karl Perrault is an associate from our Montreal office. His varied practice is mainly focused on product liability, disputes in the construction industry, and consumer law. If we could go to slide 3, please. Just a few preliminary comments about our topic today. Textbooks can and have been written about the topic of our webinar today. Since we only have an hour, our goal is to focus on some discrete topics and to try and give you some practical advice to use in your day-to-day practice. Our first topic today is mistakes and rectification of contracts. In a moment, Kaleigh is going to provide some overview comments about rectification, and then Kaleigh and I will discuss two types of mistakes which may lead to rectification: unilateral mistakes and common or mutual mistakes. Just to note that there's a whole other area of law regarding common mistakes in assumptions of fact upon entering into a contract. These are the cases that deal with fact scenarios such as when parties contract for the sale of goods, but the goods don't exist. That's a separate body of law. And those issues deal with whether or not those contracts are void at common law or voidable in equity. But for today's purposes, given our time restraints, we're not able to delve into that area of the law. So with that, I will turn it over to Kaleigh to begin with a brief overview about rectification.
Thank you so much, Jennifer. So starting with what is rectification? Rectification is an equitable doctrine that allows the court to go in and correct a written instrument when the parties have made a mistake in recording their agreement. And so the most basic example to illustrate how this works is I make an agreement with Jennifer where I'm going to sell her my condo for $500,000. And we make that deal, we tell our lawyers, the lawyers go away and paper it, but it's inadvertently written down as $600,000. And I don't want to pay Jennifer that extra $100,000. And you may be asking yourself, okay, well, that sounds like a pretty simple fix. How does something like this end up in court? And many times a mistake like this will simply be dealt with by agreement of the parties. But other times you may have someone acting unreasonable who's trying to take advantage of the mistake and use it as a bargaining chip. You may have parties that simply just don't agree on what the agreement is. Or you may have a situation where the parties agree that the agreement was mistaken, but they're trying to correct it in the eyes of a third party like the CRA to get a different outcome. Next slide, please. And so the court's task here is error correction, not speculation. And so the intent of this remedy is to take the parties back to their original bargain. And we'll show you some examples in this presentation of how that works. Next slide, please. So the courts have made clear that rectification isn't a second kick at the can. It's a narrow remedy that's available when the parties have made a mistake in the written agreement that records their agreement. And so it's not available where there's an error in the agreement itself that's led to an unexpected outcome. And the unexpected outcome that we see again and again in the cases on this topic are adverse tax consequences with the CRA. And so before the Supreme Court of Canada's decision in Fairmont, which we'll go to in this presentation, there were a line of cases that let parties who had gone out, obtained professional advice from their advisors, and entered into agreements that they thought would be tax advantageous or tax neutral, and then later got a big bill from the CRA and wanted to go back and correct that. So that's something that Justice Brown put an end to in the Fairmont decision, concluding that courts can't modify an instrument simply because the parties have discovered that it leads to an unexpected tax outcome. And on the next slide, we'll see a caution that we see again and again in the cases, that rectification must be used with great care. And what courts are really concerned about is undermining commercial certainty, which is the policy goal of contract law. They don't want to see commercial parties coming back to court again and again, trying to go back in time and rewrite a transaction's history. And later in my presentation, I'll get into some examples of how that operates. But for now, I'll turn it back to Jennifer to talk about unilateral mistake.
All right, thanks, Kaleigh. So just as we said, there are two types of mistakes we're dealing with today. The first is unilateral mistakes, and the second is what is referred to in the cases both as mutual mistake or common mistake. Next slide, please. So a unilateral mistake is one where one party is mistaken and the other knows or ought to have known of the mistake. So back to Kaleigh's example about the condo purchase and the price. If we had an oral agreement that I was going to purchase her condo for $600,000, but it got written up as $500,000, then we get into issues as to whether or not the written document is a mistake because it doesn't reflect the oral agreement. And then who has knowledge of that is something that will be of interest to the court. Next slide. And then the other type is the mutual or common mistake, where both parties believe the written text of the instrument reflects their agreement when in fact it does not. So I'll leave common or mutual mistakes to Kaleigh, but I'll go back to unilateral mistakes. So next slide, please. One, just a note here that traditionally you could only get rectification for these mutual or common mistakes, but since at least 2002 and probably earlier, you can in fact get rectification for unilateral mistakes if you meet the test, and we'll talk about the test. Next slide, please. All right, so there are going to be really high hurdles are placed in the way of business people who seek to rely on their own mistakes to get out of the written terms of a contract that you've signed. So as Kaleigh said, it's going to be very difficult to get rectification. It is an uphill battle, and that is equally true in cases where we're dealing with unilateral mistakes. The leading case is this 2002 decision out of the Supreme Court of Canada, which is Performance Industries and Sylvan Lake. We've given you the site for it later in the slides. But this was a decision, a unanimous decision of the Supreme Court of Canada, Justice Binney writing. And here are the facts, because I think it may help to give you a brief overview of the facts so you can see how this might apply. So we can just stay on the other slide for now. So B operated an 18-hole golf course, and O entered into negotiations with B for a joint venture on that golf course. And the trial judge found that B and O had come to an oral agreement, which included an option for specific residential development to be undertaken by B. So there was an oral agreement that B would have the option to develop this residential development. Now, during the negotiations, B showed O photographs of the plans, and that included a double row of houses that were clustered around a cul-de-sac on the 18th fairway. But when O's lawyers reduced the terms of the oral agreement to writing, the option clause, it accurately reflected a specified 480-yard length for the proposed development, but instead of stipulating a sufficient width to permit a double row of houses, which would have been approximately 110 yards, it was written up as 110 feet. So instead of 110 yards, we have 110 feet. And 110 feet wouldn't allow this double row of houses, which the parties had agreed as a term of the option, at least in their oral agreement. Now, B, despite being a very experienced business person, actually signed the contract without reading it. So he didn't see that instead of 110 yards, it said 110 feet. And just a note to all of the lawyers watching, it actually had gone to legal counsel, and legal counsel had reviewed it as well. But I expect legal counsel didn't appreciate the difference between the 110 yards versus the 110 feet. And legal counsel were actually called to testify at the trial and had to admit that they'd never discussed this with their client. So when B years later sought to exercise the option, that's the first time that he recognized that it said 110 feet instead of 110 yards. And O said, too bad, the contract speaks for itself. It says 110 feet. That's our deal. And B said, well, no, it can't be, because our oral agreement was 2 rows of houses, and I can't build 2 rows of houses on 110 feet. So off to court they went, and 7 years later, they ended up at the Supreme Court of Canada. I think this case was originally out of Alberta, went up through their Court of Appeal, and then came to the Supreme Court of Canada. So if we could then go to the next slide, which sets out the test that the Supreme Court of Canada came up with as a result of this decision. So next slide, please. So the court says that there must be a prior oral contract whose terms are definite and ascertainable. Now, how do you prove that? If you're the plaintiff, it's an obvious exception to the parole evidence rule. You're going to go out and look at whatever documentation you have with respect to your negotiations, any email communications, any notes, agreements on cocktail napkins, anything you have that would show that there was some prior meeting of the minds with respect to what the key terms of the contract were. And you actually have to show that there was a prior oral agreement, right? It's not an agreement to agree, it's that there was a prior agreement. Now, if you're on the other side of this, of course, you're going to argue that there was no prior oral agreement, that there may have simply been a discussion, some terms may have been discussed, but in fact, the key material terms weren't agreed to until the written contract. And that any discussions you had previously were simply negotiations, and that there was no oral agreement. So you can see, if you are the plaintiff trying to prove the prior oral contract, how difficult that might be, especially given the high hurdles that the courts have set up. Now, the plaintiff must establish that the terms agreed to orally were not written down properly. That probably wouldn't be that difficult to show. If you can show the prior oral agreement, then the difference shouldn't be difficult. And it doesn't really matter if the error was fraudulent or it was innocent. How it initially occurred, that doesn't really matter. What is essential is at the time of the execution of the written document, that the defendant knew or ought to have known of the error, and the plaintiff did not. So the court's going to have to make some factual findings about what people knew or should have known at the time the document was executed. Last, the attempt of the defendant to rely on the erroneous written document must amount to fraud or the equivalent of fraud. So what exactly does that mean? I think we can look to legal definitions with respect to what is fraud, but what is the equivalent of fraud? The court gives us some assistance if we go to the next slide. So when we talk about fraud in this context, we're not talking about the tort of deceit or strict fraud in the legal sense. It has a broader, more equitable construction. Basically, the court's looking for an unconscionability with respect to the term that the defendant is seeking to enforce. So is there unconscionable conduct? Is it unfair dealing? As the Supreme Court of Canada said in this case, did someone try to pull a fast one? That's what the court is looking to. So it's not a strict legal definition of fraud. Next slide, please. But what about the fact that in this case, B didn't even read the contract, right? Sophisticated business person didn't read the contract. Should that bar an application for rectification? And what the court says is that no, it's not an absolute bar, that this is an equitable remedy, which means the court can exercise its discretion. And it may refuse rectification if, in fact, there is egregious negligence resulting in somebody making this mistake. But if you read between the lines in the case, it seems to suggest that the greater the unconscionability, the greater the closer you get to actual fraud, the more forgiving the court will be of this negligence or lack of due diligence on the part of the party who actually signed the contract and missed the mistake. So there's going to be a bit of a balancing exercise in this case. So again, if you're the plaintiff, you really want to push that the other side knew, took advantage. And in the Supreme Court of Canada case, there was actually really great evidence showing that the defendant actually did it on purpose and knew that it should have been 110 yards, not 110 feet. So if you've got those facts, that's great. If you've got something less than that, then you do have to be a little bit careful if in fact you were not duly diligent. Next slide, please. All right. I think with that, I will turn it over to Kaleigh again.
So we see a different test that applies to rectification for mutual mistake, which I've displayed on the next slide. And that's the decision in Fairmont Hotels. And what these cases often turn on is the first threshold question of a prior agreement whose terms are definite and ascertainable. And that is where Fairmont failed to convince the Supreme Court of Canada that they should get rectification. They were asking the court to convert a share redemption into a loan arrangement in the context of the sale of two of their hotels. And they were asking the court to do that after they were audited by the CRA, got a big bill, and realized that the structure that they had planned to be tax neutral actually had a big negative tax impact. And critically, Fairmont wasn't saying there was an error in the written agreement. The error was in the outcome. And Justice Brown said, well, it's not good enough to have a general intention to pay less tax, because of course that's an intention common to most taxpayers. Fairmont didn't have a specific plan to put that in action. And so that's where their case failed. And the balance of the test is concerned with the agreement being in effect, that the instrument, and when they say instrument, that really refers to the written document or the director's resolution, whatever the written form of the agreement takes. And the last branch of the test confirms that the instrument, if rectified, would take the parties back to their true agreement. And on the next slide, we see an example of that, the application of the Fairmont test in BC. So in this case, the plaintiff company sold a capital asset, and the directors of the company agreed that what they wanted to do was pay a dividend out to their shareholders in the maximum amount available on a tax-free basis. And after they passed the director's resolution, they realized that their accountant had made a mistake and got a big penalty from the CRA. Next slide, please. And happily for the plaintiff, the Court of Appeal agreed that this case was exactly the situation where rectification should apply. And I'll explain why that is. So on this application, they had undisputed evidence that the director's agreement was to distribute the maximum dividend possible on a tax-free basis. So in other words, it wasn't an agreement that they wanted to pay out $500,000 and that was it. What the core agreement was max tax-free. And those were precisely the agreements that were given to the accountant. And the court was able to look to this evidence and the language of the director's resolution, which was drafted broadly enough to capture that intention. And that is, I think, a bit of a practice point for the in-house counsel and the audience, is to consider how these resolutions are drafted to be broad enough to capture the agreement and the intention, because I think they may have had a more difficult time had the resolution just been simply to pay out X amount of dollars. But here the court was able to construct it based on the Income Tax Act's provisions that they referred to and some other helpful points that were in the resolution itself. And finally, on the next slide, I'll just make a brief comment on the standard of proof. There's been some back and forth between the decisions in the Supreme Court of Canada on what exactly do you have to prove here. And earlier decisions said convincing proof. Following decision said, no, there's only one standard, that's balance of probabilities. And on the next slide, the Supreme Court of Canada sort of clears it up, saying yes to balance of probabilities, but you'll need evidence with a high degree of clarity, persuasiveness, and cogency. So as you heard from Jennifer, you need good evidence to get this remedy. And back to Jennifer for a few wrap-up comments.
Thanks. And just one further comment on damages, because as I said in the Supreme Court Canada case I was dealing with, it took 7 years before it got decided finally. You can't put the genie back in the bottle at that point. So you can in fact get damages in lieu of rectification. So if you can't actually rectify the contract and proceed under the contract, you can get damages. And there is authority to say that you will get damages, that they will include losses flowing from special circumstances known to the parties at the time they made the contract. So you can get your full expectation interest under the contract. All right, so next slide, just the key takeaways from Kaleigh and I is that this is a discretionary remedy. It is very, very difficult to get. You do not want to be in a situation where you are going to the court seeking rectification. It is an uphill battle. So on the practice points, obviously read these contracts carefully. If they do contain technical terms that you as counsel are not familiar with, what's 110 yards versus 110 feet, send it to the other people within your organization that have the expertise with respect to whatever piece of equipment or a piece of land or tax consequence that you are trying to address, so that you get the right set of eyes on this document and everybody understands what it says before pen is actually put to paper. All right, I think that's it for Kaleigh and I. And with that, we will turn it over to our colleague in Quebec to give you the Quebec perspective on these issues. Nicolas-Karl.
Thanks, Jennifer. Hi, everyone. It's a pleasure to be with you today. So as said by Jennifer, the topic of the discussion today is not necessarily errors into entering into the contract, although in Quebec, we included some slides in the presentation addressing this topic because in some cases in Quebec, the court might view a party's unilateral mistake or error might review this type of debate, keeping in mind the principles governing errors vitiating consent, which are provided by the Civil Code of Quebec for Quebec. And the Civil Code provides at Article 1400 that errors vitiate consent when it relates to nature of the contract, object of the prestation, but meaning it's essentially any essential element to the contract. There's also the concept of inexcusable error, but which a bit goes to Jennifer's comment about high hurdles when facing a unilateral mistake, especially when we're talking about sophisticated business parties. But basically, courts will place a high hurdle on sophisticated parties trying to invoke own goals or their own mistakes and in entering into the contract or in a written agreement. And 1401 provides for a concept of fraud in Quebec law, but again, not similarly as in common law. The fraud element does not correspond to a criminal behavior, but any act or omission from the other party which is intended to mislead the other party into entering into the contract would be considered fraud and could lead a court to rule in favor of the party invoking the error. Next slide, please. Thank you. And just to note that it has been ruled that failure to advise the other party of an apparent mistake in order to profit from such mistake can constitute fraud within the meaning of Article 1401 or a breach of a duty of good faith. So just keep in mind that where it's apparent, and especially where one party is a sophisticated party and the other is not, or depending on age, health condition, or other various factors, a court could rule in favor of the party invoking the mistake and perhaps even award damages if it's found that the other party tried to take advantage of that mistake. Next slide, please. So I just included a table here. We're not going to go through it at length, but just a summary in Quebec law as to what remedies are available for errors vitiating consent. So in some cases, you can ask for cancellation of the contract if the error is sufficiently material, and in cases where the error is caused by the other party's fraud, then damages can be awarded. That's the gist of it. Next slide, please. And again, the concept of inexcusable error, just wanted to make a note that case law has determined that inexcusable does not necessarily mean gross negligence, but it's somewhere between simple negligence and gross negligence, but it has to be negligence of a certain gravity, taking into account all relevant circumstances, including whether a party is a sophisticated party or a large corporation with assistance from counsel or experts. So again, something to keep in mind. Next slide. So now we're delving into the main topic today, which is rectification of errors in the written instruments, so in the written contract. In Quebec, the source of the court's power to rectify an error in the written contract is not equity, it's the principles provided by a Civil Code of Quebec governing contract interpretation, most notably Article 1425, which provide that common intention of the parties rather than adherence to the literal meaning of the word shall be sought in interpreting a contract. And again, like Kaleigh said, it would be the same in Quebec, that the principles governing rectification will not usually be invoked where both parties agree to just rectify the written instrument and there's no third party contesting, including tax authorities. So in most cases, you'll have, if both parties see that the document intended to reflect their agreement includes a mistake, then you can rectify that mistake through another written instrument, through another piece of paper rectifying the error. And in 95% of cases, that's going to end there, and there's not going to be any further discussion. There's not going to be court, it's not going to be needed to go to court to debate whether the criteria, which we're going to look at together, are met. Most cases dealing with such principles involve tax authorities, which challenge the parties' rectification of the original written agreement. There could be other circumstances where either one of the parties does not agree that there was a mistake, which would go to what Jennifer discussed with respect to unilateral mistake. There's not so much discussion in Quebec law between a distinction between unilateral mistake or common mistake in the written agreement. This similar principles will apply. But again, like in most cases, it's gonna deal with one party or tax authorities or another third party challenging the party seeking the rectification's interpretation of the agreement, and it's in that context that we're going to end up in court. Next slide, please. So the leading case in Quebec civil law for contract rectification is Quebec v. AES, which was rendered by the Supreme Court in 2013, which clearly provides for the applicable criteria. So first, corrections being sought must be necessary and legitimate. They must reflect the true intent of the parties. They cannot offend the rules of civil evidence, and I'll go back on that point in more detail. They must not compromise the interest of third parties. And one key principle established by the Supreme Court in that case is that if both parties agree to rectify an agreement that does not reflect their common intent, tax authorities do not have an acquired right to benefit from an error made by the parties. So the end result in AES would be similar to what was found in Fairmount and the other cases cited by Jennifer and Kaleigh as in common law on that point. Next slide. So we see a quote here from the Supreme Court of Canada in AES, but essentially saying that contract in civil law in Quebec are based on the principle of consensualism, which means that the most important part is the meeting of the minds between the parties, whether that meeting of the minds occurred in oral form or in writing or whatever form, but the meeting of the mind forms the agreement and then is reflected in a written instrument. And if a private writing contains an error, the court, if the error is demonstrated according to the rules of evidence, the court can remedy the error. Next slide, please. And when we refer to rules of evidence, and that may be the only difference between Canadian jurisdictions and especially between Quebec and the common law provinces. But obviously you have to prove the prior agreement. That proof has to be made with admissible means of evidence. So there may be objections raised on evidence that the party seeking rectification is trying to adduce. In the Civil Code of Quebec, there are a few rules which can be invoked, which in most cases will not necessarily prevent the evidence from being adduced, because if you have, for example, exchanges of emails supporting the existence of the prior agreement, or you have any type of evidence like this that can lead the court to conclude that there's a legitimate debate to be had on that point. In most cases, it's pretty rare that we see that these rules being successfully invoked to bar evidence. However, it remains possible, and these rules vary from jurisdiction. So while the general principles of rectification are similar across Canadian jurisdictions, depending on where you are, you may face some additional challenges based on particular rules of evidence. In AES, this was not an issue simply because the tax authorities did not raise objections on evidence. But in future cases, it could be the case that we see more discussion on that topic if tax authorities or other third parties or try to challenge the admissibility of evidence, and cannot be taken for granted that it will always be admissible. Next slide. So, and in Jean Coutu v. Canada, which was the follow-up case to the AES case, and the Jean Coutu decision was rendered at the same time as the Fairmount decision in common law. And the Supreme Court of Canada confirms in that decision that despite their different origins and the fact that principles in Quebec are provided by the Civil Code, and that in common law provinces, rectification is an equity remedy, at the end of the day, in both cases, the true agreement is paramount, not its intended consequences or effects. So in most cases, you'll see that the legal systems across Canada will have the similar results, which is something that the Supreme Court of Canada wants to favor. So when Kaleigh said previously that consequences, the fact that the parties intended for a transaction to be tax neutral, that this is not sufficiently precise to constitute an error, and that the error must be on the specific operations that were contemplated by the parties, these principles would similarly apply in Quebec as well. And so here you have a slide just with the key cases in Quebec addressing both rectification, but also errors vitiating consent. And with that, I'll hand it off to Alex to discuss the severance and blue pencil rule.
Very good. Thank you, Nick. Great. So I'll be addressing the principle of severance, also known as the blue pencil rule, and then also the doctrine of contra preferendum later in my discussion. So to begin, the concept of severance. This concept comes into play when a clause in a contract is illegal, invalid, or unenforceable. And so we see this in cases where a criminal interest rate is included in a contract, or where you have an overly broad restrictive covenant. Restrictive covenants are contracts in restraint of trade, and so they are against public policy unless they meet certain tests. And if they don't meet those tests, they're unenforceable. And you see it in other cases too, such as clauses that breach franchise legislation. but there are many other examples. And so this doctrine of severance, or the blue pencil rule, is restricted to a specific clause that is unenforceable or illegal, rather than the substance of the contract being unenforceable or illegal. So if you have a contract itself that is against public policy or is unenforceable because of illegality, I'll give an easy example, like a contract to purchase illegal drugs. That contract's void. It's unenforceable. No court can lend its aid to enforcing such a contract. So we're just here to orient everyone. We're just here speaking about a contract that is generally valid, but there is a clause within it that is illegal or unenforceable. Historically, these clauses, really there were two options available to the court when dealing with such contracts that had these clauses. If the court felt that it was inappropriate to sever the offending clause, then the contract itself would be void ab initio. That is, if the court did not feel that this could be severed or struck out, the entire contract would go. And so there's a significant risk to having such clauses, obviously, in contracts, and typically parties, I don't think, are including them intentionally. It's usually an accidental or unknowing inclusion. So option number one to a court is that the entire contract is just unenforceable. The second option in the historical formulation of this doctrine was that the offending clause could be struck out, and the formulation of this was with a blue pencil. But always historically, this was without adding any words. The court wouldn't amend the agreement. It would only strike out the illegal or unenforceable clause. And you have to meet a certain test to be able to do that. There are various considerations, but the primary one is the severed clause has to be independent of the other clauses in the contract and not drastically alter or significantly affect the meaning of the remaining clauses in the contract, because it wouldn't make sense and you wouldn't be meeting the party's intent if you were to strike out a clause and effectively make some substantive change to the contract. So critical to this historical approach was that no words could be added. And again, that was to try and maintain as closely as possible what the parties had in fact intended to agree to. And so just as we saw with rectification and mistake, the party's intent is the governing principle. But if some portion of the contract is struck out, then you really aren't enforcing what was agreed to between the parties. And the concern here is that the very clause, which the court has now drawn a blue pencil through, may have been critical to one or the other party or to the contract, and the other party may not have agreed to the contract if that clause wasn't included. So already in the historical formulation of this doctrine, we were in a place where the full agreement between the parties was not being enforced or adhered to, and the court was considering whether to strike out some portion of the agreement and move away from the intent of the parties. Next slide, please. The historical approach to severance and the blue pencil rule changed with the decision of the Supreme Court of Canada in New Solutions in 2004. This was a criminal interest rate case. The rate in the contract exceeded 60%. Now, it's not as though these parties just decided to put in a rate that was higher than 60%. It wasn't as simple as that. They were sophisticated parties. The agreement was a complicated commercial agreement. And there was varying calculations and formulas that went into the parties' agreement, contingencies that might occur. But keep in mind that in a criminal interest rate situation, the definition of the interest rate in the criminal code is extremely broad. It takes into account fees and administrative costs and other things that people might try and include with the point of saying, well, you can't call an interest rate something else and pretend it's not an interest rate. We're going to include all that in the calculation to see if the rate exceeds 60%. And so that's what happened to these parties. They had a very high interest rate, but they had other fees and charges that were included under the definition in the criminal code. And so the rate ultimately exceeded 60%. The Supreme Court in New Solutions took all of that into account and said, look, these parties did agree to all of these fees and charges, and they didn't intend to agree to a criminal interest rate. They intended to agree to a very high interest rate. And what we had here were sophisticated commercial parties. So this is not a case of somebody who is vulnerable or an imbalance of power that you would often see in a criminal interest rate case, somebody who's desperate. These were sophisticated parties. And so the court was striving here to try and allow these commercial sophisticated parties to reach as close as possible to what they'd actually agreed to. And that's where this phrase that, striking out the interest clause entirely, the traditional formulation of the blue pencil rule, would do violence to the contractual intent of the parties, because they did intend and were satisfied to agree to a very high interest rate. And so the Supreme Court in New Solutions sort of went out on a limb and adjusted the law of severance to conclude that this concept of notional severance should be applied. And that was applied initially by the trial judge, and the Supreme Court of Canada accepted that adjustment. And so we'll go to the next slide. The principle of notional severance is a principle that moves off the traditional formulation of the blue pencil rule, because words can be added under the concept of notional severance, and the contract can be rewritten by the court. And so in this case, the court, in fact, did rewrite the illegal clause in the contract and lowered the interest rate so that when taken into account with all the other fees and charges, the rate would be exactly 60%, which is the highest possible legal rate. The criminal code provision prohibits rates in excess of 60. And so that's where we take this concept of notional severance from the New Solutions decision of the Supreme Court of Canada. Now, there are quite a number of cases which I've begun to list on this slide considering severance since New Solutions was decided in 2004. And we'll go to the next slide, please. And so we've listed the cases here, and I'll now go through and discuss some of those in some detail. Next slide, please. Of note is the Supreme Court of Canada's decision in Shafran in 2009. This is a case that received substantial press. The point of Shafran was that from a policy standpoint, no kind of severance would be applied in an employment agreement context. And so typically these types of cases will arise in employment agreements that have restrictive covenants, where you're asking an employee not to compete for a period of time and in a certain geographical area after they leave their employment. And if the relationship is an employment relationship, then on a policy basis, effectively what the court said was, that isn't the kind of contractual relationship where we're going to exercise our discretion to adjust these clauses. If the clause is too broad, if the employee only ever worked in Ontario and you prohibited them from competing in Alberta, That's too broad. And so we're not going to sever that clause or notionally read it down to say only Ontario. We're just not going to enforce it because it's an employment arrangement, and typically the employer has the power, not the employee, and we're not going to support that. If the employer's made a mistake in the agreement, too bad for them. It won't be enforceable. So that's Shafran. Dow is a case where the contract in question contained an express severance clause. And those who work with commercial agreements regularly will have seen these. They've now become part of the boilerplate in virtually all commercial agreements, where the parties expressly agree that if some provision in the contract is unenforceable or invalid, the rest of the contract will be enforced without that clause. And the court said in Dow, the Alberta Court of Appeal, that those clauses are not determinative. Just because you have an express severance clause, the court isn't necessarily going to apply the blue pencil approach or notional severance if there is an illegal or unenforceable clause. The court must still go through the process of determining whether the original agreement should still stand with that clause struck out or adjusted, and that's a discretionary decision. But the clause is of some relevance. It's not irrelevant because it tells the court what the party's intent was, and so the clause will be taken into account. Next slide, please. And in Dow, the court went on to say that, the concern here is that if you sever a clause because of its illegality or unenforceability and enforce the rest of the contract, that may give one party to the contract a windfall or impose an unfair burden on the other party, and the court won't countenance that. They're not going to enforce that type of severance. And so, you really have to have still a fair and a commercially reasonable bargain at the end of the day if severance is to be applied. The 217 Ontario decision from the Ontario Court of Appeal speaks to the policy considerations that'll be applied or assessed when considering severance. And the point made by the court there is the policy concerns rise to the fore when you're considering an illegal or unenforceable clause, because you're being asked by one party to still lend the court's assistance to enforce the remainder of the contract. And in that case, the court may not want to do so because this party has included an illegal clause in their contract. Next slide, please. Citywide towing is a case out of Alberta, the Alberta Court of Appeal. And here we had the same sort of restrictive covenant that wasn't enforced in Shafran. But in this case, the policy concerns did not apply because the employment agreement was really part and parcel of the sale of a business. And so the imbalance of power that existed in the typical employment context did not apply in citywide, and severance was applied to reduce the geography of an otherwise unenforceable clause. Next slide, please. Key takeaways are that severance may be available to save an unenforceable or illegal contract. The inclusion of a severance clause won't clearly determine whether severance will be applied, but it will be helpful. And the other thought there is you don't want to just include those boilerplate clauses without thought. If there is some concern about the enforceability of a clause, you may want to strike out the severance clause if you're the one that might benefit should the clause be held to be unenforceable. Next slide, please. Contra preferendum is the next subject that I'm speaking on. And of course, most of us will recall this rule. The case reference here is to Manulife and Conlon from the Supreme Court of Canada, but this is a longstanding doctrine. It does require first that there be actual ambiguity in contract terms. And if there is, and in other circumstances that we'll discuss, the words of the written document will be construed against the party who drew it or drafted the document. Next slide, please. And so in Ledcor, another decision from the Supreme Court, this doctrine of contra preferendum was refined. First of all, the court said there has to be a true ambiguity. And the court then said that the ambiguity should first be resolved, if possible, using all other principles of contractual interpretation first. That is, you don't include contra preferendum in the basket of tools that you have to resolve ambiguity. First, you would apply other methods of resolving ambiguity. And so these are things like assessing the reasonable expectations of the parties, assessing first the outcome of cases if the contract is a common type of contract, such as an insurance contract, for example, assessing what other decisions have said about this type of contract, using the surrounding circumstances to determine if the ambiguity can be resolved by that method. And it's only if all of those methods fail and the ambiguity cannot be resolved that you would then turn to contra preferendum as a last resort. And then you would interpret the ambiguity against the drafter. But first, you have to go through the other methods to see if you can find a way to resolve the ambiguity. Next slide, please. Ironside and Smith from the Alberta Court of Appeal is another restriction on the doctrine of contra preferendum. And in that case, the principle was that the doctrine does not apply when both parties have had a meaningful opportunity to negotiate the wording of the clause or the contract. So, in most commercial agreements, both parties are having some input into the wording of the agreement. There may be one party that is the principal drafter, but then they send it over to the other for comment and revisions, and there may be some back and forth. Of course, that's not every circumstance. In other circumstances, the contract is drafted and there is no meaningful opportunity to negotiate. But where there is, contra preferendum does not apply. Next slide, please. And so the key takeaways on contra preferendum are that the doctrine requires a true ambiguity first. There has to be an A or B option in the interpretation of a clause. And you first then have to exhaust all other doctrines of contractual interpretation to try and resolve the ambiguity. And only if you can't resolve it using all those, you can turn to the last resort, which is contra preferendum. And all of this only applies where the parties did not have an opportunity, both of them, to engage in negotiation and drafting. And so it's going to be a fairly restrictive doctrine on the basis of all of that case law and analysis. And with that, I'll turn it over to Nick to speak about the Quebec application of these principles.
Thanks, Alex. I'll try to go quick since we're going a bit over on time. There's actually some key differences to take into account between Quebec and common law jurisdictions for the severance and blue pencil rule. The Transport v. New Solutions case cited by Alex is based on equity. It's a common law decision, and it has not necessarily been applied in Quebec the same way. In Quebec, the severance and blue pencil rule is, we could say, governed by, especially provided for by Article 1438 of the Civil Code of Quebec, which is shown on the slide, but basically says that a clause which is null does not render the contract invalid unless it is apparent that the contract, unless the clause was so integral to the overall agreement that the court decides to render the whole contract null and void. And so next slide, please. So the court will first look at this article to analyze a severance agreement. Quebec courts are not usually do not want to rewrite agreements, even if parties have provided for a clause allowing, for example, the court to apply the minimal restrictions allowed by law. This is not something Quebec courts like to necessarily see, and they don't like to rewrite agreements. So in determining whether to sever a clause, an invalid clause, or void the entire contract, the court has some discretion. Next slide, please. And in that context, it can consider a clause included in the contract saying, for example, if such and such clause is voided, then the parties agree that the entire agreement will be null and void. The court will take that into account in its analysis pursuant to 1438 to determine whether it should consider just the clause itself to be null and void or null the entire agreement itself. Alex discussed the Supreme Court of Canada's case in Chaffron, a decision in Chaffron v. KRG, which provides that the court will not rewrite non-competition or non-solicitation clauses in an employment agreement. If such clauses are null, then they won't be rewritten. There was a case cited by Alex saying that in a commercial context, that the court may agree to rewrite the clause. That is not the case in Quebec. The courts have found that they will not, even in a commercial context, rewrite restrictive covenants such as non-competition and non-solicitation clauses. So that's one thing to keep in mind in terms of differences. In Quebec, the court will simply not rewrite a clause that goes outside the parameters, the criteria established by case law for restrictive covenants, including that it include a reasonable territory, that it only concern specific activities and the duration. If the clause is too broad and is abusive, it will simply not be applied. However, if there's a non-compete clause that is invalid, but there's also a non-solicitation clause that can be considered separately, the court can and has found that in such cases, if the non-solicitation clause, for example, is valid, you can strike out the non-compete clause and leave the non-solicitation clause, as was found in GPL Assurance v. Barca, cited in this slide. Next slide, please. As for contra proferentum, I will go very quickly because honestly, the principles are very similar in common law jurisdictions and in Quebec. This doctrine is essentially applied as a last resort, and even this rule in Quebec is provided by Article 1432 of the Civil Code of Quebec, which makes a difference between contracts of adhesion and consumer contracts with other contracts. With other contracts, it's in case of doubt that, and as a last resort, you could say that contra proferentum will be applied. In contracts of adhesion and consumer contracts, it always applies, but case law has found that even though it always applies to such contract, does not necessarily mean that a consumer or adherence interpretation will always be favored when there are two possible interpretations, but just that if through other means the ambiguity or doubt cannot be resolved, it will always favor the consumer and adherent. Next slide, please. Next slide again. And just to finish on this point, the notion of contract of adhesion is provided by Article 1379 of Civil Code of Quebec. It's basically where one party dictates the terms and the contract is non-negotiable. However, it's not because a contract is pre-drafted or is drafted by one party does not necessarily mean it's a contract of adhesion. It's a question of fact whether a contract is a contract of adhesion, and it's not even necessarily because it's a specific type of contract. There has to be evidence that the adherent party tried to negotiate it, but was told it was non-negotiable. There has to be some proof adduced to show that it is a contract of adhesion. And finally, just to point out that this notion will probably receive more attention from Quebec courts in the coming months and years, since the new Bill 96, which has added new requirements to the Charter of the French language in Quebec, has included additional requirements for contracts of adhesion, even between commercial parties. So even between sophisticated parties in a commercial context, these requirements can apply. So the requirement that the contract be drafted in French and that the documents related to that contract be in French. So there will be probably a lot more cases in the coming years discussing what is a contract of adhesion, and every corporation dealing in Quebec should understand these rules. And we have great materials prepared by our team specialized in Charter of French language in Quebec that are available and could be provided if you wish. They're available on our website, and we have a lot of great conferences and training available for this. And that's it for me.
Thank you, Nick. All right. Well, thanks everyone for joining us today, and for forgiving us for going a little over time. And thanks to my fellow speakers for your efforts and preparation for today. Please do consider completing the survey. It will only take a moment and allows us to improve this seminar series. So we very much appreciate it if you do that and provide your remarks. The next webinar in our commercial litigation series will take place in October. Please keep an eye on your inbox for the invitation, or you can visit our website and head to the Fasken Institute section to see the list of upcoming events. Thanks again, everyone, and have a great day.